continuing legal education here. I'd like to welcome you all. I'd also like to begin by thanking our all-volunteer faculty, many of whom are not yet present, but all of whom certainly have given very generously of their time and talents in preparing the materials you have, as well as their presentations today. As you know, we're completely dependent on their efforts, and we're certainly very, very grateful for them. I have a few announcements of a more mundane nature. Once again, I'm obliged to remind everyone that this is a non-smoking facility, though the Intrepid may grab smokes just outside the east entrance where you came in. As you pass through that entrance, you probably noticed a staircase on your right. If you follow that to the bottom, there are pay telephones. A rather severe jog to the left around from there will bring you to the men's washroom. The women's is most conveniently found by walking through the main Law Society reception area and down the stairs, asking at reception if that's not sufficiently clear. You'll have, of course, a binder of course materials, and I just want to draw your attention to a few features in it and a couple of omissions as well. There's a gray program evaluation form, and we take these very seriously. These are, in significant measure, what guide us in planning programs that will best meet your practice needs. And you would do us a great favor, as well as acting in your own self-interest, if you were to keep this by you during the course of the day and to complete it and turn it in at the registration desk before you leave. If for any reason you can't do that, please do fax or mail it in after the fact. You will see that there is no paper from Brian Greenspan, and will not be. In the section provided for Earl Levy's paper, you'll see a notice saying that paper is available for, or will be available for pickup at the registration desk at the end of the program. Otherwise, the binder you have should certainly be complete, and please ask at registration if it is otherwise incomplete. Mr. Justice Sopinka will certainly be here, is not here yet, so I won't introduce him, but certainly I will proceed to introduce his co-chair, Michelle Fuerst, whose biography, along with those of the other faculty, can be found inside the binder. Ms. Fuerst is a partner in the law firm of Gold & Fuerst, where her practice is restricted to criminal and quasi-criminal litigation. She's a specialist in criminal litigation, and the other facts set forth in the bio will help explain why her nickname in the CLE department is the Overachiever. Please join me in welcoming Michelle Fuerst.
Welcome to the program. What we have tried to put together today is a compilation of experts in their own field of litigation, both civil and criminal, to talk to you about basic principles and some more sophisticated techniques that you might want to think about when you're preparing and choosing experts to testify. And then we hope to finish up at the end of the day with a panel discussion about where we go after the Supreme Court of Canada's pronouncement in Mohan, and we're pleased to have with us a distinguished counsel from the United States who is going to give us some assistance as to how the whole area of expert evidence has been developing in the United States after the Supreme Court of Canada, or Supreme Court of the U.S. decision in Dobert. So we hope you'll be able to stay until the end and to hear that last panel. Our first speaker this morning is Eleanore Cronk. Eleanore is, of course, a well-known litigator practicing in Toronto and a partner in the firm of Fasken Campbell Godfrey. Again, Eleanore's significant accomplishments and achievements are set out in the biographical materials. She is perhaps best known as a former president of the Advocate Society. Eleanore is going to talk to us today about choosing the expert. Eleanore?
Good morning. Those who are asked on programs such as these to speak first up at 9 o'clock in the morning know they've either done something egregiously wrong to someone along the course of their career to date, or the hope is that people at the conference will have a coffee, wake up by 9:30 and pay attention to Ian, Binnie, and Brian Greenspan. So I leave it to you to which choice you want to make. I usually start my contribution to sessions dealing with expert evidence by quoting extensively from the poem Jabberwocky, Some of you may remember that from Alice in Wonderland and Through the Looking Glass. And I do start with that because it seems to me that it is the ability to translate what that poem means is very analogous to a precondition to ability to lead with expert evidence. It is translating through a looking glass someone else's world. It has been said that choosing the expert, picking the right expert, is as important a strategic choice to the effective management of a litigation case as is the subsequent task of marshaling facts and preparing your case strategy. I believe that to be true in the context of what you're going to hear this morning. I think my job is to provide a context for you of what you should be thinking about at the beginning and perhaps some suggestions as to a checklist that you can add to over time or change significantly depending on your success-failure rate with those you choose to use as experts. So that's what I propose to do for about the next 10, 15 minutes. It seems to me that when you talk about the topic of going about, of how you go about choosing an expert, that the place to start, and forgive me for reminding all of us of perhaps a rudimentary aspect of this, is the case assessment. And that is, does your case really need an expert? And if so, on what specific issues, what facts, what facets of your case are going to require opinion evidence in order to make out your case? So you will see when you come to read my paper, if at all you do, that the place that it starts is the issue of case assessment, case analysis. Do you need, is an expert necessary for your case? And if so, quite specifically, for what purpose? And I suggest that that's where your analysis at the beginning of the case must start. It's also important to remember, as everyone in this room of course knows, that the ability to call expert evidence is an exception to the general rule that we all know, and that is, generally speaking, opinion evidence is neither receivable by the court nor the trier of fact nor admissible because it is not based on first-hand direct knowledge by the witness to be called. So it helps to remember from the beginning that you're dealing with an exception, that there are all the qualifications problems that you're going to hear about from subsequent speakers, and it becomes important, in my view, to ground your thinking about your array or single experts from the beginning and the purpose for which they're being called. The role of the expert, of course, has been discussed in a myriad of cases, most recently, as Michelle alluded to, in the Mohan decision of the Supreme Court of Canada. I've referred to former Chief Justice Brian Dixon's well-known obiter in the Regina and Abbey case in the paper. It helps to remember the definition of the courts that set out the constraints within which opinion evidence can be offered and the true role of the expert. The traditional view has always been, of course, as everyone in the room, this room knows, that the purpose of the expert is to assist the trier of fact on matters which require a knowledge and understanding of either technological or scientific evidence which is beyond the natural purview, that is, the ordinary course of understanding and knowledge of the trier of fact. That's an interesting concept in contemporary terms because of some of the decisions that have been emerging from the Supreme Court of Canada in the last several years. I say that because I wish to make this suggestion, that while it is the case that there has been for a number of years and is still a growing concern about the proliferation of the use of experts and the dependency in the litigation process increasingly and in the recent past on the use of opinion evidence, that is accompanied, in my view as well, by a recognition by the Supreme Court of Canada that the bases on which expert evidence may be proffered are expanding. And I offer you two examples. One of the cases referred to in the material is the Levy case. Some of you will recall that that was a case in which it was sought to introduce expert opinion evidence to explain to the trial court the effect of the battered wife syndrome, what was called the battered wife syndrome. Madam Justice Wilson in that case made it quite clear that in her view, first, the mental state of the alleged victim of the crime could not be understood in the absence of expert evidence that explained her behaviors, that is, the behaviors of the woman involved, in psychological and psychiatric terms. But the starting point in a legal construct for the admissibility of that evidence was twofold. First, that an explanation for the trier of fact of the psychological effect of behaviors by one who was alleged to have suffered from the battered wife syndrome was necessary and relevant to the court for the determination of the issues that were before the court. But secondly, that it was a means by which the court could ensure that where appropriate, it had the information before it to debunk, and I use that word with some care because you'll see that repeated in a number of cases, to debunk mythical and stereotypical notions that might exist in the minds of the public, not only in the context of spousal abuse, but as well in other potentially misunderstood forms of human conduct. What that led to then, in my view, and I ask you to consider this, is two bases on which the evidence was held to be admissible. First, as being relevant and necessary of assistance to the trier of fact, but secondly, as a means by which to test the real degree of familiarity of the non-psychiatrist, the non-expert on human behaviors. What's implicit in that, in my view, is a re-examination of how true it is that the average member of society has an understanding of facets of human nature without assistance from those schooled in disciplines that assist. So that line of cases opened the door, or at least confirmed, that kind of opinion evidence could be introduced to explain such matters as behaviors that might otherwise have been taken as evidence of recantation, evidence of a bad character that suggested unreliability in the complainant, to explain to the court the implications of low self-esteem, poor communications with others, late reporting, or what seemed to be late reporting, so that it's a very interesting discussion, sometimes expressly stated to be on the basis of when expert evidence will be available on new subject areas, but also the very practical aspects on which you can seek to lead an opinion, expression of an opinion from an expert. The second example I offer to you is what's been happening recently in cases involving sexual abuse of children. Same kind of approach, in my view, in the sense that opinion evidence has been held to be admissible and receivable by the trier of fact to explain the types of behavior seen in children who have been allegedly sexually abused. So that, for example, opinion evidence now, on the basis of cases that have been emerged from the Supreme Court of Canada in the last several years, can be led as to whether certain kinds of behaviors in children are consistent or inconsistent with sexual abuse. When you think about it, that's really quite an extraordinary advancement, in my view, in the type of evidence which can be led from experts, because it goes a long way before a jury or a trial judge from a prosecution point of view, and obviously in rebuttal by the defense, creating a situation in which the probability of the offense is heightened. So that I commend to you the cases in those two areas as a recent reflection of an expanding view of the types of circumstances in which expert evidence will be received. What they illustrate, I suggest, is that triers of fact are being cautioned that their views by experience and background might be tainted by mythical and stereotypical notions of what is normal human behavior. And in that sense, if you view it in that sense, it seems to me that the door is at least potentially very widely opened now for the introduction of opinion evidence. How then do you decide in practical terms, in any case, when you need the evidence of an expert? I've set out in the materials that I provided to you this morning a number of case examples from NIDA materials, that is the National Institute for Trial Advocacy, authored by Jim Seckinger, who many of you will know, that try to provide three very specific examples of how you might go about testing when you need an expert to prove either a fundamental fact in your case or a fundamental feature of your case. And by moving through those three, it seems to me that it's a helpful illustration of the kind of analysis you have to go through to see when an expert might in fact be required in your case. If following an assessment of your case, you've reached the conclusion that you do need opinion evidence, the next issue, it seems to me, then, is when, then, should the expert be retained? I don't mean to be trite when I suggest to you that the finances of the client permitting, as soon as possible. And the reason for that, of course, is because experts can provide an array of assistance, can perform an array of tasks for you in preparing your case and in beginning to present your case and beginning to begin to deal with the opponent's case, whether or not there's any requirement or expectation that they testify at trial. Too often, I think, the analysis of when expert evidence is required focuses on whether they're going to testify. And there is a role for experts, certainly born of the American experience and in the Canadian experience as well, for the expert who it is never intended should be a witness. You'll see in the materials, for example, reference to the practice in some cases in the States of retaining a litigation consulting expert in addition to a trial testifying expert. What's meant by that is that in an appropriate case, again, finances of the client permitting, that you actually engage an expert to be your counsel advisor or experts as your advisors throughout the course of the litigation, with no expectation that those individuals will ever testify for a variety of reasons, and that there is then a separate analysis that is undertaken to determine who the appropriate individuals are to testify as witnesses at trial on your behalf. In Canada, of course, the custom has been that an expert performs both functions, but in appropriate cases, more in the administrative law field and in complicated commercial cases, I have to say, but increasingly there is the experience in this jurisdiction, at least in my experience, of a supervisory expert being retained. And the function of that individual is to supervise the work product of your other experts on your own team, and to supervise and advise you on how to cope with and how to begin to prepare to deal with multiple experts from the opposing side. An individual of that kind really performs an expert case management function on the litigation team with no expectation that he or she will actually testify. The examples I give you are very lengthy administrative tribunal hearings where, for example, it's not uncommon in either the environmental field or the planning field to be in the situation where you're either leading evidence through panels of witnesses, panels of experts, or cross-examining, in some cases, 5, 6, 7, 8, 9 experts at a time. Some of the now pending Royal Commissions of Inquiry, including, for example, the Creever Commission, provide a very interesting example of that. When you're dealing with a case of the kind where you know you're not talking about coping with 1 or 2 subject-specific experts, but panels of experts, then supervisory experts on your team, someone who is the general advisor on dealing with an array of technical evidence and opinion evidence that you're going to have to deal with, is a very useful thing. Again, finances permitting. So when I say to you experts should be retained as early as possible, it's with a view to distinguishing between the pre-trial, pre-adjudication role of an expert and the role actually at trial or at adjudication, and whether both your budget and the case warrant the involvement of both types of individuals. What kind of person then do you look for? Now, anyone who is ever called an expert in any kind of a case, be it in the public law, administrative law setting, or in the civil litigation context, has their own private, very qualitative checklist, whether consciously delineated or not, of the kind of person you're looking for. But can I suggest to you what, in an ideal world, the testifying expert should look like? It's been said by another author, and perhaps I can offer this to you because I share this sentiment. The ideal expert is someone who can present dynamic, riveting testimony to dazzle the trier of fact. The person should be pleasant and charming. I don't know about that. Person should be pleasant and charming, intuitively know when to be quiet, and have every possible degree and credential, an impressive array of awards and honors, and a long list of authoritative publications that address the main issues in your case, as well as considerable hands-on knowledge of the people, places, or things at issue. Commentator goes on to say, if you find such an expert, please let me know, but in the meantime you must determine which characteristics are most important in your case. The facetious implication of the remark, of course, is that an expert like that is God's personal dean of academia. They are hard to find. In appropriate cases, that is the kind of individual that you're looking for. These are the factors that I think should be on everyone's checklist when searching for an expert in any discipline. First, and we all, I think, know this, but you start with the objective qualifications and training of the proposed expert. What is the actual hands-on work experience background of the individual? What is the nature of the academic training? From what kind of an institution? Is it one that is peer accepted, that has been recognized to be a legitimate in the area of relevant discipline? What is the actual CV of the expert, and will it stand up to a qualifications attack? What some people sometimes forget in the examination of the qualifications and expertise issue is to ask yourself, what kind of a profile does the expert really have to have? It is not every case, of course, that needs or permits the internationally recognized expert. There are cases where that is very much required. There are cases where the local expert, or indeed even the newcomer to the field, is an entirely appropriate expert witness. But sometimes in the search for the ideal, we assume we need, and I use the term euphemistically, the dean, when often you don't. So you have to, I think, begin to examine what is your forum, what is the issue on which you're calling the evidence, and what is the stature or profile of the expert we really need. In those cases where you are seeking to have the courts break with past precedent and establish new law, or advance only an emerging theme, a side aspect of an established body of law, it is, in my experience, more necessary in those cases that you get the heaviest expert you can find. Where, however, you are asking the courts to deal with and to uphold a traditional view of the law, to not break with what the body of case law has suggested, or really to engage in a more classic form of analysis that's well supported by the case law, you don't necessarily need that kind of person. So I wrap up in the qualifications and objective training search the issue of, well, what kind of profile does this witness really have to have? Again, always remembering the financial capacity of the client who's permitting you to retain the expert. Some people also, in that search for perhaps the less than ideal, but certainly the more than satisfactory expert, forget, I think, two practical things. These are often difficult to do in advance of the actual retainer. We all know that sometimes we're scrambling to get the expert on board, and it's sometimes, unfortunately, quite late in the game. But where time permits, and when you embark on this exercise at an early enough stage, two things I suggest are very important. The first is ask the proposed expert, but then check yourself. Has he or she testified in previous cases? And if so, was their evidence accepted? If it was rejected, on what basis? And look at the cases. Confessions at 9:30 in the morning are dangerous things, but I will say to you that I am one counsel who has had the experience of relying on the expert's characterization of his prior experience, only to find, shortly, thank God, before cross-examination, that the court's reasons for the rejection of his evidence were a little bit more direct, thank you very much, than I would have liked. And had I known about that well in advance, it could very well have influenced the decision to hire the individual. So where time permits, don't rely on what, first of all, ask, but don't rely on what they tell you. Check it yourself. The same thing applies with prior publications. On every experienced expert CV, you're going to see either one page or, depending on the field, certainly in medicine, 47 pages and continuing, references to publications, some peer-reviewed, some not. It's important when you go through that, before retaining the expert, to make sure that the opinions expressed in previously published materials are not inconsistent with the position that you want to advance on behalf of your client. Sometimes what's forgotten outside of the medical expert field is that the partners of your proposed expert can taint him or her with a view that becomes embarrassing on cross-examination. So that I have added to my checklist over the years, not only what have you published in the area, and may I please have copies of them so that I can take a look at it, what have your partners said about it, if it's that kind of an individual that you're retaining, because that too becomes a useful weapon in the arsenal of the opponent if it becomes the suggested expression of a firm view. Approach and demeanor, we all know, and the introductory comment certainly suggests that what you're looking for is someone both skilled in communication skills, but someone who both appears to be and is, to the extent possible, truly open-minded and unbiased. Some of the cardinal things that emerge from the cases, and we've all had the experience of this going wrong, is the expert who too early on or from the beginning, either because of prior experience or because of a desire to assist, becomes an advocate for the cause. That's our rule. That's not their rule. That's our rule. It is a cardinal mistake for counsel, and I know you're going to hear further about preparing experts, how you go about working with them both on their report, what's proper in that domain and what isn't, but it is a cardinal rule to gauge yourself from as early a point as you can whether this is someone who both in chief is going to be too free with his or her opinions, too quick to go beyond the area of their expertise with gratuitous add-ons, and more particularly, what are they going to do under cross-examination when somebody tries to stretch them? If they're there advocating, seemingly with reluctance to concede even the easy, you've got a very real problem on credibility assessment. So attitude and demeanor, are they open-minded? Does their writing reflect an objective approach? Do they communicate in objective terms? Do they fight you a bit on coming to the conclusions that you would have them express? Do they fight you a bit on accepting direction from you as to their opinions? If they don't, you have a problem, in my view. If they accept too readily that kind of direction from counsel, it's not going to be real hard to demonstrate that on cross-examination. Time permitting, my suggestion to you is you now do in the modern world the kind of beauty contest for experts that clients do for us, and that you do your own unidentified mock cross-examination and you push a bit. You try to determine what kind of chemistry you're going to have with the expert, whether it's someone who is going to be able to communicate well with you, who is inclined to a respect for the process and an ability to educate you on the field of their discipline. Some are not. Some have either legitimately by experience or illegitimately by perception only, a disdain for the process, do not work well with lawyers. They communicate that in a courtroom. There's an edge of arrogance that creeps into the subtext of their remarks that you can hear in your office, and you should be looking to hear it when you're gauging their attitude and their demeanor. Added to that checklist very quickly, I've referred to one case in the materials. It's an American case, Wells and Orthopharmaceutical. I included it not because there's any particular jurisdictional insight in that case that we don't have here in Canada, but because it is rare outside the administrative law field to see decisions which deal at length with the factors that judges take into account in assessing credibility and assigning weight. That was a battle of the experts case, and you will see a lengthy discussion in the reasons of the trial judge in that case as to why he accepted the evidence of an array of plaintiffs' experts and rejected an array of the opinion evidence of an array of experts for the defense. It's a useful reminder of the kinds of things that a trial judge actually must address his or her mind to when they come to assign weight when confronted with multiple witnesses and conflicting opinion evidence. And very useful exercise to be reminded of that. You'll hear further, I suspect, when you hear about preparation of experts, about methodology and how important it is to test that early on. There are some in this room, perhaps, who are gifted with dual disciplinary training and can instruct an expert on and comment by virtue of prior experience or extensive knowledge in a particular field on the type of methodology the expert should use. More commonly, most of us who struggle with this don't know a whole lot about the field of the expert except what prior cases has taught us. You have to really make sure that you understand the methodology that they're proposing to use in preparing their work for you, and much more importantly, there's a due diligence obligation on you as counsel, in my view, to check out yourself and not just to take the expert's word for it that his or her methodology is accepted in the scientific community. If it isn't and it's groundbreaking, ask yourself why and determine whether that is something that you can legitimately advance in your case and defend, and find out what peer review articles have said about the approach and this particular expert's published works on the approach or the method of analysis, his or her theories. That is not something on which one should simply, again, accept the expert's word. There's an interesting tactical issue to summarize very quickly about what do you do about experts from outside the jurisdiction? What about in-house experts? When is it appropriate to call them or retain outside? Remember, of course, that your client, particularly in the commercial but not exclusively commercial litigation field, is the primary source of knowledge about potential experts, but also potentially the repository of immediate expertise. The danger with it, of course, is that none of them will ever be perceived as truly independent, and there will be an inference of partiality from the beginning by the fact of association with their employer. So it's a dangerous thing to do in that sense, but a very useful thing to do often in many cases. The tactical implication of the expert from outside the jurisdiction is the one that you'll immediately appreciate, and that is, unless you need to go heavy, if I can put it that way, unless you need the dean, I don't mean that literally in the academic sense, but the leading expert or one of the leading experts, there is a danger bringing in international experts, particularly in the jury setting, certainly in the administrative law setting, that there will be a subtext of resentment because it is not a Canadian expert. Where it's an emerging field, where you've had difficulty finding anyone with the appropriate expertise, different situation. Where it's a battle of experts and they're going to hear from a panoply of them, different situation. But remember that bringing somebody in from outside carries with it some very real strategic implications, and they shouldn't be lightly dismissed because those experts do carry an aura with them, deservedly or not, before the trier of fact. Finally, on the checklist, I'd suggest that you consider overall whether the individual, if it's a testifying expert that you're going to retain, whether it's an individual who can speak in a way that you clearly understand and that you believe the judge, the jury, or the adjudicator is going to be going to be able to understand. What I'm saying to you is beware the expert, like the lawyer, who retreats to jargon. Many of us do it under stress and in the face of cross-examination. Fortunately, it's the witnesses we call who usually have to deal with that. We don't have to experience it ourselves. But the people who defend their opinions, who by virtue of their instinct when under attack retreat to the incomprehensible, are very dangerous experts for you. It's got to be somebody. It doesn't have to be the world's most articulate individual, though if you can find them, I'd like the name. But make sure it is someone who, under pressure, when you go through those mock exercises, really does make their field understandable, can explain it in simple terms. It doesn't have to be dressed up in complexity to be persuasive. And if they can't persuade you, either at the time that you're exploring the issues with them or at the time you're preparing them, they're not going to be able to explain it to anybody else in a way that's compelling. I was asked as well to talk about how you actually go about finding a real one. Here's Cronk telling you about the ideal. What do we do to actually find a real one? There are, of course, established mechanisms and ways to go about that. They're listed. There's no particular profound insight, I assure you, in that list. But start with your colleagues. Whether you've done this kind of case before or not, somebody else has. Some of them you can talk to. Start always with your client. They are industry experts in the commercial context and what you're dealing with. They will certainly know as a starting point to whom to refer you if they don't know experts themselves. Find out who they have in-house who can prep you on the kinds of issues that are going to have to be covered by your expert. You know, of course, that there are established search houses, commercial houses, both here and in the States, who will find for a fee provide you with a list of suggested experts in a particular area, and those are published agencies, published houses. You know that the universities and the research institutes in Canada and the trade associations are enormously fertile grounds for appropriate experts. My rule is this: start with the client, walk the hall to my colleagues, and pick up the phone. And when in real difficulty, remember that there are lists out there published both by the Bar Association in Canada, the Advocate Society, and like groups in other provinces, and their companion organizations in the United States. You'll find very briefly in the paper, and I'm going to stop because A, I've gone too long, and B, because Ian Binnie's here, and why wouldn't you want to listen to Ian Binnie? Because I certainly would. You'll find commentary in the last part of the section on where we're going in the future on this whole issue of the use of expert evidence and what some of the reform initiatives are calling for in that regard. Some of you will know, for example, leaving aside what has been suggested in the Civil Justice Review Team's work here in Ontario, that in England in June, a major civil justice reform document was released by Lord Wolfe, which calls in part for sweeping changes in the area of expert evidence. That's happening in several other jurisdictions as well. What's interesting in those recommendations are these kinds of concepts, that there should be an increased court-controlled use of experts defended on the basis that those kinds of experts are truly more neutral and will be less partisan. Leaving aside the debate we might have about that, that is the trend that's emerging from the reform reports that are coming out. What that suggests to me, and what I commend to you, is this: that we should begin to think more often than we now do about whether a jointly agreed upon single expert is an appropriate way to go in cases where traditionally that wouldn't have been considered in the past. To be case managed either by a judge or by a counsel team for both the plaintiff side and the defense side, but will a single expert jointly agreed upon with terms of reference or retainer or engagement letter jointly settled be possible in your case. If it isn't, you face the danger, I think, in the future that somebody may tell you that that's the way it's going to work. So I ask you to think about that. Thank you very much for your attention, and I hope you enjoy the rest of the day. Thank you.
Our next speaker is Ian Binnie, who is a specialist in civil litigation and a partner with the firm of McCarthy Tetro. He's probably the only speaker you're going to hear from today whose CV indicates that his experience ranges from Tanzania through The Hague and to Saint-Pierre and Miquelon. He is going to speak to us on the topic of preparing the expert, and I understand is going to touch on the recently discovered post-testimony distress syndrome. Ian?
Thank you very much. I'm exhausted just listening to Eleanor. My topic is to prepare the expert witness, and I have produced a paper which is at tab B of your materials, which you might want to open up simply because there are some interesting quotations sprinkled here and there through the piece. The first task, it seems to me, in preparing the witness is to make up in your own mind what the objective of the exercise is. You'll see this quote on the first page of the paper that the cynical definition of an expert witness is someone chosen not for their wisdom or sagacity, but for their willingness to say in the simplest, clearest, least tentative way what a particular side wants said. Now that is perhaps a little cynical, but the reality is that as the lawyer, what you are looking for is somebody who can say what can reasonably be said on behalf of the technical position necessary to support your client's case. I see the expert witness as performing in the expert field very much the same kind of thing as the lawyer performs in the legal field, and that is to say that you take the raw materials of the case, you give it some kind of shape, and to the extent the trier of fact can reasonably be persuaded that what is being said is logical and appropriate, that is the task to be performed. The problem with all this is that that is very much a lawyer's perspective. And what I deal with in the first part of this paper is the significance crisis that many witnesses go through, many experts, as to what extent should they be drawn into this process and to what extent are they being compromised in their professional integrity by, in effect, pleading, although in a very elegant and tasteful way, for one side of the case. And here it depends very much on the area of expertise. I always think that it runs a spectrum from the specialties before some administrative agencies, which are really recognized nowhere outside those agencies, all the way to pure university disciplines that have nothing in common with the courts. In the first category, I would put people like the retail survey economists at the municipal board who develop theories of department store type merchandise generating shopping demands and then assessing whether those demands are being met. Now those people are termed experts, but really the only preparation that is required is to indicate the result that you're looking for, and effectively they do the rest. At the other end, you have, in the Aboriginal rights cases, people who are in the field of archaeology, anthropology, to whom the structure and methodology of the court is entirely foreign. I recall in the Bear Island case, there was an expert called to discuss canoe shapes in northern Ontario in an effort to persuade the court that the group in the Temagami area were had greater affinity with the easterly bands than the westerly bands. And in the courtroom, there were a bunch of canoes littered around, and the expert was traveling from canoe to canoe, discussing the shape of the bow and the construction. Now, to deal with that kind of individual, it seems to me requires a great deal of preparation. And what I have set out in the paper is some statements by legitimate scholars who have been caught in this conundrum. And as they see it, and as is indicated in the first quotation at the bottom of page 2, it's a matter of balance. Everything about their expertise demands balance, and it demands an open mind so that they will assimilate new information as it comes and be ready to vary their opinions in light of new information. And that, of course, is the antithesis of what is expected in the court. You'll see in this quotation the plea of the historian saying, it's not we were engaged in formulating lies, there was nothing as crude and naive as that, but we were using facts, emphasizing facts, bearing down on facts, sliding off facts, quietly ignoring facts, and above all, implementing facts in a way to do what Marshall said we had to do, get by the boys down there. And that, to many experts, is a real problem. And unless you can somehow reconcile the scholar, the expert, with the task confronting the expert in court, you're going to have a very unsatisfactory witness for the judge to listen to. On the next page, there are a couple of other factors that bother experts and a number of articles which you might read to see the expert's side of the litigation process and why it creates cultural differences. In the first quotation is this whole issue of finality that I alluded to a moment ago. In the second is the lawyer's theory that two equally unbalanced presentations coming into collision somehow produce the truth. And the economist in this case was analogizing it to Adam Smith's idea that everybody working in their own interest somehow cancels out for the greater good. And this is a methodology that is not only foreign to most scholarly fields, but is repugnant to it. I then give a couple of instances of the judicial view of experts, which by and large is highly jaundiced. The Delgamuck case, Chief Justice McEachern, Delgamuck was the great Aboriginal rights case in British Columbia, and there were historians attempting to explain the impossible. That is to say, the courts have created this concept of Aboriginal rights, and they require evidence as to what were the activities carried on by a particular group of Aboriginal people in a particular area at the time that the British asserted sovereignty over North America. Now, in a culture which has no written records and only oral testimony or history, which is generally thought to be reasonably reliable back perhaps 2 or 3 generations, the courts have laid on people, Aboriginal people, a test which in fact, to any scholar, is incapable of being met. And when this was pointed out to Chief Justice McEachern, his ruling is, as you find it on page 4, simply to say, well, I'm sorry, that's the law. We're going to have to hear evidence as to what was going on in British Columbia in the early 18th century. And we're going to have, at the end of the day, finality and closure and a statement of what, in the view of the court, was the case. And to the historians participating in the case, that was an impossible mission. Then there is, from the ever colorful Justice Muldoon, a quotation of what he thinks of experts, which you can read at your leisure. But he does wind up with the interesting statement that cross-examination is said to be the great engine of getting at the truth, but when the unschooled judge cannot perceive the truth, if he or she ever hears it amongst all the chemical or other scientific baffle-gab, is it not a solemn exercise in silliness? And that, I think, points up another problem, is that the expert has lived with the expertise for years through the whole educational system and through his or her professional life. The judge is suddenly plunged into it within half an hour of a case starting on a Monday morning, and part of the preparation of the expert is to try to bridge the gulf in understanding, as well as the gulf in the cultures of the courtroom and academia. Then there's a little bit in the paper about the view from the bar. I like this statement by Professor Kauser at the bottom of page 5, where he says, attorneys tend to believe their own experts are pure, even to the point of being too prissy to agree to state their own conclusions in a way that would be most helpful to the lawyer's clients, while the other sides are merely lying for money. What that leads to in terms of preparation, I think, is the conclusion that without knowing who, at the end of the day, your trial judge or your trier of fact is to be, you have to strike a balance between the credibility of the subject matter that is being put forward and the credibility of the expert who is the spokesperson for that subject matter. And there you run into, I think, quite serious limitations, because very often a judge who is listening to highly scientific information is going to be entirely lost and is going to make rather general findings of credibility based on demeanor and whether the witness looked the judge in the eye and various other indicia which may have absolutely nothing to do with the correctness of the testimony. At the same time, there are judges who are bright and inquiring and will want to come to terms with precisely what it is that the expert is attempting to say and the methodology by which that testimony was arrived at, and the assumptions underpinning the testimony. And for that kind of judge, quite a different approach is appropriate. So you have to proceed with preparation with both aspects in mind. Now, Eleanor has already spoken of the selection of the expert. Essentially, in practical terms, it is a matter of identifying somebody who historically has supported the kind of ideas that you have to put forward to the court. This is no way to impeach the independence of the expert, but is simply to say that if you find somebody who is of that persuasion, then they are likely to have written and testified consistently with that view in the past. The expert that we're talking about, of course, covers a huge gamut. I remember years ago a case involving an exploding teapot where the plaintiff was badly injured by boiling water from the teapot and complained that the teapot had spontaneously exploded. The manufacturer's theory was the only way this could have happened is if the teapot had been put on a source of heat on the stove top, and it was the heat then that fractured the pot. The first witness we called was as to the proper method of making tea. And we located an elderly Scottish landlady in the annex who was duly qualified as an expert in not having the teapot on the source of heat, but adding the boiling water and the tea bag. We then had somebody from the Corning Glass Company who had spent the greater part of his career smashing ceramics. And he was able to say with perfect conviction, because it's really the only thing he knew, is that the fractures spread out from the source of heat, so that under a microscope it is entirely apparent whether the heat source was from outside the teapot, which was the defense theory, or inside the teapot, which was the plaintiff's theory. Getting the expert on side. This is a very important aspect of preparation, because to go back to what I said initially, you really look to the expert to perform on the expert's subject matter the task you perform on the legal subject matter. And ideally, it is the expert who sits down, analyzes the problem at a very early stage, and formulates the approach so that from first to last, it is the expert who is in charge of that aspect of the case. There is nothing worse than for the lawyers and the client, particularly a client who believes that he or she knows everything there is to know about the expertise, developing the case and then inviting the person who actually has to present it in the witness box at a later stage in the preparation. In going about that, obviously, you're going to want to know everything that the expert has written or testified, as Eleanor pointed out, and general readings in the area of expertise. But having said that, in terms of preparing the expert's report, which I deal with starting at page 9, I think it's terribly important not to allow the expert's participation to take over the preparation of the report at too early a stage. Experts may not be aware that when they climb into the witness box, some counsel are going to demand all kinds of background documents, drafts of reports, and so on and so forth. And although the cases are divided, there is good authority for the view that when an expert climbs into the box, he waives privilege, or the client, by calling the expert, waives privilege over those pretrial materials. It seems to me that there should first of all be a discussion with the expert in considerable detail as to what the case is all about, and to have that discussion continue until the point where something can be reduced to paper, but when it is reduced to paper, it should be in point form. And I give a number of reasons for that in the paper. And one of them is simple efficiency. An expert can labor over a document at great time and expense that ultimately is useless, because what was significant to the expert from an academic point of view is really not germane to the focus of the lawsuit. I think the expert should be told that the report has at least 3 broad functions. First of all, clearly where rules require that the report be delivered in advance, as they do both in the federal court and in the general division, there is the element of advance warning, and the expert should realize that something not in the report may well be objected to and ruled inadmissible, so that it has to lay out all of the elements that the expert has to deal with in order to support the ultimate conclusion. The second function is acting as a kind of roadmap or script during the presentation. And it seems to me very important that the expert have something that he can keep pulling back the judge or the jury or the administrative tribunal or the cross-examining counsel back to the structure which the expert has tried to create in the report. The report should be a framework of how the expert says the trier of fact should think about the expert issue. And what you have to do from the first of the case to the dying moment is to keep pounding home that framework. Because if the judge accepts the framework, it is likely that the judge will think about the case in the way your expert thinks about the case and deliver the answer that you're trying to achieve. Thirdly, of course, the report carries on arguing long after you sit down. And in a decision that is reserved, it may be many months before the report is actually addressed from the perspective of writing the decision. Dealing briefly with the concluding part of this paper, in terms of oral testimony, I think it is important, as I state at page 13, that the expert realize that in a substantial way the expert is in charge of the presentation. I don't want an expert to feel that he or she is simply responding to the ritual of the courtroom and to the questions of counsel. I want the expert to climb into the witness box, look at whoever the fact trier is, keep his eyes on that person, watch for when attention is straying, watch for looks of confusion, deal with it as an exercise of explaining to somebody in an informal setting exactly what the expert is trying to say. I think in that exercise, the lawyer doing the examination in chief is purely a bystander to throw in questions for emphasis, to throw in questions for narrative, but the art of persuasion is taking place between the expert and the trier of fact, and the lawyers shouldn't get in the way, and the expert should understand that that is the nature of the exercise. In terms of cross-examination, I think the expert has to understand essentially what cross-examination is all about. And at the moment, most experts conclude that the O.J. Simpson case is the model. And that sets a completely inappropriate mindset for the expert witness, because the expert should understand that the attack is going to be on the assumptions. It's going to be on the unarticulated aspects of the expert testimony. And I think the expert has to understand that, of course, legitimate points have to be conceded, but more than that, that there is no damage to an expert in making such concessions. That fundamentally what the expert is there to respond to is an attack on those essential elements supporting the opinion expressed. And there should be an ability on the part of the expert to be candid and balanced in dealing with the penumbra, as it were. The expert should be cautioned that when assumptions are put to the expert, they can be dealt with not only by direct commentary, but by incorporating those assumptions into the expert's own framework. In other words, if somebody were to attack a calculation of the production of something or other, and it was pointed out that certain figures in the calculation are open to challenge. The most effective way for the expert to deal with that is not to get into a huge argument about the figures, but is to take out a calculator and say, well, if you're right, and feeding that into my analysis, at the end of the day, the difference is only 0.0003, which is entirely irrelevant. So that the task which I think the expert has to understand is that cross-examination is not a battle between the expert and the cross-examining counsel. It is a battle for the expert to retain the attention and the respect of the trier of fact, and the way in which that is done is by appearing reasonable and trying to assimilate the cross-examination into the expert's own theory of the case. In conclusion, I've listed a few points in the latter parts of this paper that you might want to discuss with the expert, having to deal with some of the tedious particularity of responding to cross-examination. Thank you very much. Post-treatment, post-testimony distress syndrome. Page 18. Many experts, I think, become as anxious as lawyers about how the presentation went. And inevitably, it did not go as well as the expert had hoped. And I like the statement which is reproduced here by Justice Jackson of the Supreme Court of the United States, speaking in terms of lawyers. But he says, I always made these three arguments in each case. First came the one that I planned, as I thought logical, coherent, complete. The second was the one actually presented, interrupted, incoherent, disjointed, and disappointing. The third was the utterly devastating argument I thought of after going to bed that night. And it seems to me experts should be warned that this is the trauma that they're going to suffer, and to be ready for it and to put it behind them. Thank you.
Good morning. Our next speaker will be Brian Greenspan, and after that there is the, well, they should call it the health break to be politically correct, the coffee break. And I wonder if the members of the panel could assemble up here. We'll grab our coffee and we'll have a short meeting during the coffee break. Brian Greenspan, of course, is known as a prominent criminal lawyer. I haven't had too many opportunities to observe him at trial, but I do on appeal regularly, and he's one of the finest appellate counsel in the country. He's a past president of the Criminal Lawyers Association. When we had a telephone conference to structure this seminar, he was very critical of our decision in Mohan, which I wrote, because we had reversed the Court of Appeal and not accepted his argument. Since then, last week, we reversed the Court of Appeal, but accepted his argument, and he's in much better humor this morning. Brian Greenspan will discuss qualifying the expert. Mr. Greenspan.
First of all, at the outset, let me apologize to you for not having a paper in the materials, and hopefully there will be something structured on the basis of what I've been writing since about 6 o'clock this morning, to provide you with something of more substance to take with you. Albert Einstein once said that the whole of science is nothing more than a refinement of everyday thinking. If that were true, we would never need experts in the trial process, nor would expert opinion be admissible. The fundamental threshold for the introduction of opinion evidence is to furnish the court with scientific information which is likely to be outside the experience and knowledge of the trier of fact. If on the proven facts a judge or jury can form their own conclusions without help, then the opinion of the experts unnecessary. Until recently, and indeed until the judgment of the Supreme Court of Canada in Mohan, which I'll make further reference, our highest court has been generous in its acceptance of expert testimony and in liberally interpreting its relevance to material issues. The admissibility of expert evidence involves a matter of competency, which is based in large part on the qualification of the expert. Competency involves a question of law alone, which is to be determined by the trial judge. The expert evidence must be given by a witness who has demonstrably acquired special or peculiar knowledge through study or experience in respect of the matters upon which he or she undertakes to testify. Thus, before the court will receive expert testimony on matters of substance, it must be established that the witness possesses sufficient background in order to provide assistance to the court. I might first deal with the mechanics of qualifying the purported expert, a person who one commentator observed is one who has limited himself to his chosen mode of ignorance. There are two fundamental issues to address. Firstly, the competence of the expert to provide the proposed opinion. Secondly, the issue which has become more complex and problematic, and that is qualifying the competent field of expertise. Traditionally, qualifying the expert is focused almost exclusively on the first criterion. That is, as a condition precedent, it's incumbent upon counsel tendering the witness to establish before the trial judge as a preliminary matter the testimonial or experiential qualifications of the proposed witness. The qualification of the witness to proffer opinion evidence is frequently, if not routinely, established before the trial judge in the presence of the jury. Counsel proposing the witness will endeavor by questioning to have the witness qualified in the relevant field in virtue of his or her skill, knowledge, or experience. Opposing counsel will be asked as to whether he or she is content that the witness be so qualified, and if not, will be afforded the opportunity of addressing questions to the proposed witness or making submissions on the preliminary issue. The trial judge will then normally make a determination on the preliminary issue, the result of which will determine whether any opinion will be heard upon the proposed subject from the witness presented. The necessity to qualify a witness to give expert testimony is not indigenous to the opinion rule. It's as much a requisite of a witness testifying to a fact that the witness have first-hand knowledge of the substance of the offered testimony. However, the requirement of testimonial or experiential qualification on the part of an expert witness is not limited to the preliminary proof of such qualification before the trial judge. The need for such qualification of necessity implies, firstly, that the subject matter of the testimony must be so distinctively related to some field of specialized endeavor so as to be beyond the knowledge of the average juror. Secondly, that the proposed witness have sufficient skill, knowledge, or experience in the specialized endeavor to make plain that the opinion will probably aid the trier of fact in reaching a just determination. And thirdly, that the proposed witness not provide an opinion beyond the scope of the skill, knowledge, or experience acquired in his or her field of specialized endeavor. It's for the judge to determine whether the proposed witness has undergone such a course of special study or experience as will render the person expert in the subject matter of the proposed testimony. It would appear clear that while the proposed expert must be skilled by special study or experience, it is unnecessary that such skill be acquired exclusively in any particular manner. In some cases, academic qualifications alone may suffice, whereas in others, practical experience without educational refinement will serve to qualify. In 1894, it was held that a solicitor, notwithstanding that he had acquired his knowledge as an amateur, could be treated as an expert in handwriting. I suspect possibly based on signatures on retainer checks. It should be added that specialization, whether by education or experience, is a matter of degree. There is no doubt a threshold of experience which the proposed witness must possess before becoming an expert. But thereafter, the breadth or narrowness of specialization is a matter of degree and therefore a matter of weight and not admissibility. In Sopinka, Letterman, and Bryant's Law of Evidence in Canada, I'm told that every lecturer today is required to make at least one reference to the text. I do so, my lord. Reference is made to the fundamental definition of the expert, and that definition was offered by Chief Justice Falconbridge in 1912. The derivation of the term expert implies that he is one who by experience has acquired special or peculiar knowledge of the subject of which he undertakes to testify. It does not matter whether such knowledge has been acquired by study of scientific works or by practical observation. Hence, one who is an old hunter and has thus had much experience in the use of firearms may be as qualified to testify as to the appearance which a gun recently fired would present as a highly educated and skilled gunsmith. If opposing counsel wishes to challenge the admission of the expert's testimony, he or she should do so immediately after the expert has stated his or her qualifications and prior to the witness testifying on the matter in issue. If such a challenge is raised, the issue becomes that preliminary question for the judge alone to determine. Opposing counsel, as I've said, can cross-examine the witness as to his or her qualifications. However, if no objection is raised before the expert testifies on substantive matters, then any cross-examination as to qualifications goes only to weight, not to the admissibility of her or his testimony. This should be distinguished from the situation where an expert gives evidence outside the field in respect of which he or she is qualified. In that instance, and I'll deal with Mark Card shortly, it is immaterial that no challenge was made at the time the witness was qualified. Failure by counsel to object to the expert's qualifications at an early stage is only a bar to a subsequent objection so long as the witness stays within his purported area of expertise. This perhaps exhausts the first, and I suggest the less current and less contentious aspect of the threshold problem of the expert witness's qualifications. The other issue has long been recognized, but not really tied inextricably to the qualification issue, but rather to the general area of the admissibility of opinion. But Professor McCormick, in his text and in his original work, stated that opinion evidence is not admissible if the court believes that the state of the pertinent art or scientific knowledge does not permit a reasonable opinion to be asserted even by an expert. So it's on occasion forgotten that that which animates the exclusionary aspect of the opinion rule may not be the qualifications of the proposed witness and the knowledge, skill, or experience in a particular field, but rather the subject matter of the testimony, the questions being asked, the answers being sought and given. To put the matter in a somewhat different way, a witness's qualifications are not the sole determinant by which the opinion rule is engaged. The subject matter must be qualified along with the expert. This issue is further obscured by almost a visceral skepticism by lawyers and judges of the behavioral sciences and an antithetical and almost blind acceptance and awe in the precision of the physical sciences. Prior to the judgments of the Supreme Court of Canada in Marquardt and in Mohan, Justice Moldaver, sitting as a trial judge in the case of Mallarney and Longpre at Brampton, and I remind Justice Moldaver that, strangely enough, it was Valentine's Day 1992. This was a shooting case, the Valentine's Day massacre case. But he insightfully analyzed the problems related to potentially unreliable scientific evidence. And that scientific evidence was being offered by potentially an unreliable scientist. So there was the combination of ingredients that really dealt with quality and qualification of the expert and quality and qualification of the science involved in the expression of the opinion. Procedurally, and I think this is very important, he conducted an extensive voir dire to properly arrive at the threshold ruling in the jury's absence. And it would appear that where the issue relates to the quality in terms of the admissibility of the scientific evidence, that should take place in the jury's absence. The evidence related to the tracing of the firing line of a bullet, and to some extent it was based upon glass fracturing and the bullet's impact. Justice Moldaver observed in ruling that the opinion could be heard, much to my brother's chagrin. Ultimately, there was an acquittal, so it balanced at the end of the day. It may well be, said Justice Moldaver, that a jury will side with Professor Thornton, he was the defense expert, assuming he testifies at trial, which I believe he did, and conclude that Mr. Carroll, who was the Crown expert, is unable to be so precise in his charting of the point of impact. However, that does not render Mr. Carroll's evidence inadmissible. It simply goes to the weight of his testimony. I am therefore satisfied, based upon the evidence of all three experts, that the proposed evidence is sufficiently reliable from a scientific point of view, that its exclusion for that reason is not warranted. In other words, I'm satisfied that the proposition upon which Mr. Carroll bases his evidence amounts to something more than an unvalidated or speculative hypothesis. That, however, does not end the matter. Merely because the proposed evidence passes a minimum threshold test of reliability does not in and of itself lead to its automatic inclusion. When the Crown seeks to tender evidence which involves a new scientific technique or body of scientific knowledge, it must, of course, establish that the evidence is relevant and that it passes a minimum threshold test of reliability. As well, the evidence must be outside the experience and knowledge of the trier of fact, and it may only be tendered through a properly qualified expert. Assuming that these preconditions have been met, I'm of the view that a number of other factors should be canvassed before the evidence is admitted. And then Justice Moldaver listed some of the criteria. But what we have here is one of the very first attempts to marshal a standard and a clear test for the qualification not of the expert itself, but a qualification of the expertise. And that's then carried on later by the Supreme Court of Canada in Mohan. Justice Moldaver used these 9 criteria. The Supreme Court of Canada refined it to 4. These 9 standards. Is the evidence likely to assist the jury in its fact-finding mission, or is it likely to confuse and confound the jury? Is the jury likely to be overwhelmed by the mystic infallibility of the evidence, or will the jury be able to keep an open mind and objectively assess the worth of the evidence? Will the evidence, if accepted, conclusively prove an essential element of the crime which the defense is contesting, or is it simply a piece of evidence to be incorporated into a larger puzzle? What degree of reliability has the proposed scientific technique or body of knowledge achieved? Fifthly, are there a sufficient number of experts available so that the defense can retain its own expert if desired? Next, is the scientific technique or body of knowledge such that it can be independently tested by the defense? 7, has the scientific technique destroyed the evidence upon which the conclusions have been based, or has the evidence been preserved for defense analysis if requested? 8, are there clear policy or legal grounds which would render the evidence inadmissible despite its probative value? And finally, will the evidence cause undue delay or result in the needless presentation of cumulative evidence? Justice Moldaver goes on to say the list is not necessarily exhaustive. Furthermore, the importance of any one or more of these factors will vary depending on the particular circumstances of the case. There then, following this, and this is in 1992, there's then a focus of opinion at the Supreme Court of Canada on the issue, or a refocus of opinion, as a result of really what has become almost a cottage industry of experts, and particularly in the area of abuse. If we go directly to Marquard, which is the judgment of the Supreme Court of Canada on October 21st of 1993, Justice McLaughlin, speaking for 8 members of the court, Justice Leroux Bay in dissent. In one of the areas, and this was a case that you may recall where a young child received certain burns, and the burns were reflective, in the view of certain abuse experts, of abuse. As well, there were the abuse experts and the burn experts, and they were two distinct categories of experts. Justice McLaughlin, in dealing with the notion of opinion outside the area of expertise, spoke as follows. The appellant submits that the judge erred in admitting opinion evidence given by experts outside their area of expertise, and further erred by failing to instruct the jury that this evidence was to be disregarded. Dr. Meehan was qualified as an expert in child abuse and in pediatrics. She was not qualified as an expert in burns. Nevertheless, she thrice voiced the opinion that the child had suffered a contact burn and not a flame burn. And that was a very important issue in the case. In cross-examination, she admitted that she was not an expert in burns or plastic surgery. Dr. Campbell, who saw the child upon her arrival at Wellesley Hospital before referring her to the Sick Children's Hospital, was not qualified as an expert. He acknowledged that he was not an expert on burns. He testified, however, that his experience led him to the conclusion that the child had suffered a contact burn. Dr. Zucker was qualified as to the nature or origin of burns. He's a highly well-known head of the burn unit at Sick Children's Hospital. He went beyond this area of specialty to testify that passivity during a medical examination was characteristic of abuse. So we have the abuse specialist testifying with respect to burns, and the burn specialist testifying with respect to abuse. This somehow did not offend the Supreme Court of Canada. The trial judge admitted the evidence. Although she accepted that the witnesses had gone beyond the area of expertise as qualified, she did not instruct the jury to disregard the opinions which went beyond the witnesses' area of expertise. On the contrary, she invited the jury to place weight on these opinions, stating that opinions outside the expertise of the witnesses were to be weighed along with all the other evidence. Defense counsel did not object to the witnesses giving evidence in these areas. However, he strenuously objected to the judges charging the jury that they could rely on the opinions outside the stated areas of expertise. The problem raised in this case stems from the way the witnesses were qualified as experts. There is little doubt that they all possessed some special knowledge relating to the matters on which they testified, alleged to lie outside their area of expertise. While Dr. Meehan and Dr. Campbell were not medical specialists in burns, there can be no doubt that as practicing physicians they possessed an expertise on burns which is not possessed by the ordinary untrained person. Similarly, while Dr. Zucker was not qualified as an expert in child abuse, his long experience working with children who had been injured had no doubt given him a degree of expertise which is not possessed by the layperson. The only requirement for the admission of expert evidence is that the expert witness possess special knowledge and experience going beyond that of the trier of fact. Reference then is made to Beeland in the Supreme Court of Canada. Deficiencies in the expertise go to weight, not admissibility, and then there's another reference to Justice Sopinka, Justice Letterman, and Professor Bryant's book. Reference number 2, my lord. The problem in this case is that the witnesses were qualified more narrowly than their areas of expertise, or in the case of Dr. Campbell, were not formally qualified at all. The proper practice is for counsel presenting an expert witness to qualify the expert in all the areas in which the expert is to give opinion evidence. If this is done, no question as to the admissibility of their opinion arises. But the reality is that counsel sometimes fall short of this ideal, or the questions and answers venture into territory which counsel had not at the outset foreseen. Similarly, witnesses called to testify to facts, like Dr. Campbell, may find themselves drawn into the realm of expert opinion. The line between the actions of an attending physician and the assessments underlying these actions is often less than clear. Important as the initial qualifications of an expert witness may be, it would be overly technical to reject expert evidence simply because the witness ventures an opinion beyond the area of expertise in which he or she has been qualified. As a practical matter, it is for opposing counsel to object if the witness goes beyond the proper limits of his or her expertise. The objection to the witness's expertise may be made at the stage of initial qualification or during the witness's evidence if it becomes apparent the witness is going beyond the area in which he or she was qualified to give expert opinion. In the absence of objection, a technical failure to qualify a witness who clearly has expertise in the area will not mean that the witness's evidence should be struck. However, if the witness is not shown to have possessed expertise to testify in the area, his or her evidence must be disregarded and the jury so instructed. While I cannot approve of the procedure adopted at this trial, the fact that the witnesses all clearly possessed expertise sufficient to permit them to testify as they did leads me to conclude that allowing the jury to consider their evidence in its entirety does not constitute an error in law. So that's really the floodgates case, and it permits a very, very wide breadth and wide scope for the qualification of an expert in a very broad area of expertise, simply going beyond the knowledge of the trier of fact. It's not, however, reflective, I suggest, of the strictures that the Supreme Court of Canada then places upon the expert and upon expert opinion a year later in the case of Mohan. Because at least in defeat, the court clearly rejects the notion, which was spawned by a decade of cottage industry experts in the field of abuse, that specialized meaninglessness is not the hallmark of true science. And Justice Sopinka, for a unanimous court, they seem to want to unite when they dismiss my appeals, one of those rare occasions. He, first of all, refers to the properly qualified expert. And he states that the evidence must be given by a witness who is shown to have acquired special or peculiar knowledge through study or experience in respect of the matters on which he or she undertakes to testify. In summary, therefore, it appears from the foregoing that expert evidence which advances a novel scientific theory or technique is subjected to special scrutiny to determine whether it meets a basic threshold of reliability and whether it is essential in the sense that the trier of fact will be unable to come to a satisfactory conclusion without the assistance of the expert. The closer the evidence approaches an opinion on an ultimate issue, the stricter the application of this principle. I wonder, perhaps aloud for the first time, whether all members of the court in joining in Justice Sopinka's view realize that it would impact adversely on the Crown as well, an impact as it has in very much restricting some of the expert opinion that has been traditionally and almost routinely offered in very controversial areas, and particularly in the areas of child abuse. The Mohan case essentially follows, I hope I don't offend when I say follows, the lead of the United States Supreme Court in the case of Dobert, and requires that the trial judge ensure that an expert's testimony rests on a reliable foundation, that the methodology employed must be scientifically valid and properly applicable to the facts at issue. The judge must consider whether the theory or technique can be and has been tested, whether it has been subject to peer review and publication, whether there exist standards and the maintenance of standards controlling its operation, and whether it's attracted widespread acceptance within a relevant scientific community. The expert evidence must satisfy some minimum threshold of reliability, and as was said previously, particularly, a novel scientific theory or technique must be subjected to this special scrutiny to determine whether it meets that basic test. Although some may characterize these standards as the basis of general principles of admissibility, I suggest they're fundamentally issues of qualification. You have the two features of qualifying the expert: the expertise of the expert, him or herself, the expertise of the field of expertise. And until that field of expertise can be qualified as satisfying the standards in Mohan, then you don't get past the voir dire on qualifying the expert. Thank you.
Thank you very much, Mr. Greenspan, for the restraint that you have shown in dealing with Mohan. You'll win your next case, too. We're going to now have our coffee break for 15 minutes. I wonder if the members of the panel would mind coming up and getting your coffee, and we will retire to a room that is behind here, and we'll come back to hear Mr. Levy. Thank you very much.